organizations, by the very people who decide that they want to go into data sharing for one purpose or the other. And as data moves across various ecosystems, the agreement is not something that is just a compliance document. It is actually a way to assign or allocate risk, and it also safeguards reputation. So for us lawyers who are on this call, the task is no longer to just recycle a template, right? We all agree that we've moved away from just adapting a template. You actually need to understand certain concepts, which is what we are going to delve into on the call today with the speakers. You also need to do things like data mapping, understanding the roles of the parties. Are they controllers? Are they processors? If the contract says one party should delete after processing, do you have a way to make that work without causing friction? Now, having said all this, I just wanted to lay a foundation on the discussions that we're going to have this afternoon. So today we're going to explore how to close some of these gaps that I've already mentioned. And in order to help me, or rather in order to help us understand this topic, and make it clearer for us, we have some speakers on the call today. So I will call on the speakers in no particular order, and just unmute your mic and let us know that you're in the room with us. So I'll first start with Confidence Amuda, who is going to give us the legal and compliance focus for this discussion. Confidence, are you on this call?
Hi, so good evening. Sorry, this is not Confidence. This is Shegun, but just speaking on behalf of Confidence. He's not able to join due to an emergency, so he sent his apologies, if that's okay.
All right, that's totally fine. We hope he's doing well.
Yes.
All right, so we have Shegun Alade on the call. Shegun, thanks for being here with us. Shegun is going to give us, the commercial and business strategy focus during this discussion. Do we have Ikionana Ezekiel on the call? Can we confirm if we have Miss Ikionana Ezekiel on the call? Oh, she's here. Can you unmute your mic? I'd like for us to make sure that our speakers are able to unmute their mic and, if possible, to also share their videos so we can actually see who's talking to us.
I think she should be able to unmute now. She can unmute her mic and speak.
Okay.
Can she try unmuting and let me know if it works?
Ikionana, can you please unmute your mic? Let's know if it works.
Okay, maybe you just kind of move on to, okay, I think she's trying to unmute now.
All right.
Okay. We didn't hear you. I think you're muted briefly and then you're muted again. So. Okay. I will do that. I'll fix that now. Okay, yes. Now try unmuting.
Oh, hello. It's working now. Thank you. Good afternoon, everybody.
All right. Welcome, Ikionana. It's good to have you here. So I was saying that Ikionana is going to talk to us from the technology focus and also give us some insights about practical implementation. So since we've set the tone for the discussion, let's dive right in. Let me start with you, Ikionana. Talk to us about the legal elements that must be present in any well-drafted data sharing agreement. Apart from just having a template, we all know that there are certain conditions or situations that may arise that will require you as a lawyer to modify a template, in order to make it fit for purpose. So we'd like to hear from you about these key legal elements that must be present in a well-drafted data sharing agreement. Ikionana, if you're speaking, you're muted.
Okay, I was trying to unmute, but the host could not let me. But so I got your question.
Okay.
So in terms of what needs to be part of a data sharing agreement, we know the usual legal clauses that needs to be there. It's not like our laws provide for concrete components like they do for privacy policies. I mean, the NDPA is clear on what should be contained in a privacy policy. But I don't think that luxury was afforded to data sharing agreement. So what we have is mostly what we adopt from our foundational legislation, which is the GDPR and other advanced forms of legislation. But when we look at it for context, anyone drafting a data sharing agreement should take cognizance of the sector they are dealing with. So if you're dealing with the medical sector, you have to understand what is going on, what kind of data is involved, what kind of processing is involved. If you're dealing with an ed tech company, the things may most likely be different. So in every situation you find yourself, draft and think of this component to fit the industry that is handling personal data, because data identification changes with industry and how it has been used. So where a personal data like a name, for example, could mean that it's a medical patient's data, but when it comes to an educational sector, it could be a student. So that particular identification changes from patient to student. How are you able to capture this unique identifier of the personal data in a data sharing agreement is very, very key. And it also influences how responsibilities shifts from time to time. The rate of sensitivity or responsibility attached to sensitive data is different when you're dealing with medical than when you're dealing with students. So one person can be a patient, that same person can also be a student, but with different kind of safety requirements, different kind of responsibilities for different industry. So that's one thing that needs to be mapped out. The first one is the data subject identifier. What industry is this person into? What sector am I dealing with? How sensitive is this data I'm working with? So I could go on to list the key things like the things that should contain in the data sharing agreement, like the create a background, give a background. This flows from what I've just said about identifying data, like what are the key responsibilities? Who is a joint controller? Are you talking about a joint controller? Who is responsible for what? Are you joint controllers? Are you sub processors? So all of those things need to be contained as well. After you've identified the industry, the next thing that you move on to is to identify the responsibilities of each party. Are we talking about joint controlling? Are we talking about processors? Are we talking about subcontractors? Are we talking about vendor? Are we even talking about, oh, you're a user, I am the controller? Those kind of relationships should be clearly defined. Then we also have data subject rights that needs to be stated clearly, the obligations of each controller, who does what. If you're a joint controller, what do I control? What amount of personal data is within my responsibility to handle or to dispose? That should be contained. And you have to look at who is to take responsibility in the event of a breach. I mean, if it's a processor, for example, the processor does not really have that much weight on him. It's the controller. So if it's a controller processor, we all know that, when the breach is going to occur, the controller will be the one to bear much of the responsibility. But if it's a joint controller relationship, it will be that both parties are taking responsibility. So you need to state that very, very clearly in your agreement. And also you have to think about personal data transfer. Are you transferring to third-party countries? What is happening? Is it just within us? Or is it just within Nigeria, for example? Are we using some kind of software that will make information leave this country? What kind of safety protocols are we working with? We have to look at that as well. um, you have to think about liability as well, the liability of each of those parties in the data processing activities. If there is also collaborative rights, we've talked about specific rights. So what happens where different persons have different rights? Do we share certain responsibility, or does this responsibility go solely to another person? Let me use a practical example. The first draft I worked for, the first data sharing agreement I came across was an edutech company. What happened was that the edutech was providing a particular software to a school, that the school was going to use the software to take record of the students, mark attendance. So they would upload their results into the cloud, into the software, and the software will automatically give results. Just everyday paperwork in school. So in this kind of environment, what we had to look into was who was going to bear the liability of deleting the information. And if you delete this information, what's going to happen? So if it were to be the software providers and they were to delete, it will affect the educational record on the system. So what we had to do was the school should decide, we have gotten a particular student, the student is no longer with us for a couple of years, we want to have this particular data out of our system, or we want to make sure that it is something that cannot be accessed except by so and so number of persons in the organization. So those kind of things need to be cleared out very, very well so that everybody can understand their stance. And also for compliance, they also have to agree who does the compliance and to what extent. For the agreement we had with the client, we had to agree that everybody should monitor their compliance. If you haven't registered, if you haven't conducted your audit, each person should go ahead to do that. So those kind of activities, those kind of components are key in any data sharing agreement.
All right, thank you so much. That was really, really extensive. I was actually taking notes while you were speaking. I think that's, it's very important to understand the key context before you even start drafting anything. So let's go to Mr. Segun Alade. So, Segun, why don't you talk to us about data sharing agreements from a commercial and business strategy focus? So let's think about it this way. You find yourself in a business relationship or a commercial relationship. All of a sudden, clients are talking about data, right? At what point do you actually determine that you need a data sharing agreement? So talk to us about how data sharing agreements impact on, business negotiations, commercial relationships. At what point do you even know that you actually need a data sharing agreement?
All right, thank you. It's really a privilege speaking, and I really enjoyed the last speaker. I did have a good time listening to her. To be honest, I think sometimes we need to perhaps look at the semantics and understand the difference, because in the world of data protection, Some of the terminologies might be a bit confusing, like you have data processing agreement, you have data sharing agreement. Some would even say data transfer agreement or data sharing protocol. So depending on the jurisdiction and your experience and the industry you are in, all of these terminologies, they connote different things. And it's always good for us to understand, speaking for what the last speaker has just mentioned, the context of what you're trying to do. So to answer that question, I would say, yeah, when you go into a business negotiation, from a lawyer perspective, you're supporting your client. There's always a business requirement. There's a business need. So as data protection lawyers, what we need to, our major purpose or our major work is to support business growth while enabling our clients to remain compliant with, data protection regulations and whatnot. So we are not a blocker. We are not literally saying this cannot be possible. We are literally there to support the business. So understanding the business objective, understanding what needs to be done is what we basically inform what do I need to put in place. So take, for instance, in a scenario whereby your business is sort of engaging a supplier. Maybe you are in healthcare service industry, for instance, and you need a software, your client needs a software provider who is going to provide their service in order to, deploy a particular systems within your operational environment for you to be able to carry out some certain work elements. You will know how technology is. You might not be able to actually deliver all the services that is required for a client or have all the component or the technological capacity to do that. So in a situation whereby what the supplier is doing is just carrying out your instruction, you'll be thinking along the line of data processing agreement because you are giving the instruction and the supplier is literally just acting based on your instruction. For instance, cloud providers, software as a service providers, supply chain, all of these guys, they are mostly sitting within that processor remit. But if it's a case whereby I think the best way to judge it is to look at what benefit are we getting from this data. So this organization needs the data to make certain decision or act in a certain way. The other organization that we are in negotiation with, they also need that data to carry out certain tasks. So we both need the data for certain engagement. In that kind of scenario, they will be thinking towards a data sharing agreement to sort of detail the obligations, the responsibility. If we have clarity as to how we are making decisions about the data, are we making it independently? In that case, we are independent controllers. Or are we making it together? In that case, we are joint controllers. So we need to start off from the business objective, then go on to understanding what manner of control are we going to have about that particular data set before a lawyer can then decide what specific mechanism do I need to put in place. There was also a mention about onward sharing, that is maybe transfer out of jurisdiction. Maybe you're engaging another supplier that is outside jurisdiction, transferring data out of the country. There might be a need to also take it a bit step further to put in the right mechanism for that data transfer, because sharing is in different contexts. It could be a case whereby the data is sitting within your system. You are the system owner, but you need to grant access to the other organization, maybe through API integrations or any other technological enablement for them to have access to that data within your environment. So you also have to define what type of access are you giving to them. Is it a read-only access? Is it a read and write access? So just to, because I know that quite a number of speakers on the call and so many things to look at. So I think if we want to look at the basic, in terms of relationship, business relationship, the impact, you can talk about things like control, which I've mentioned. What level of control do I have over this data set? Because we know from a regulator perspective, the data controller has a huge responsibility. They have a huge obligation. If there is any data breach, you are the first point of call to actually, that level of accountability is required from you to showcase to evidence that you have implemented the technical and organizational measure to protect that data, which data sharing agreement is a form of organizational measure because you are literally showing that you are accountable for that data set. So control is one area that basically comes to play. Then risk as well, just like the previous speaker, how do we allocate risk? If things go wrong, how do we bear the liabilities? How do we bear, all of those indemnification clauses and things like that? So I'll just wrap it up to also put it again back to where I started, which is the business objective. What are we trying to do? What are we trying to achieve as a business? What is your client? So it's very interesting or very expected to know the expectation of your client. What do they want to do? And that will help you to guide in how you sort of put in the expected mechanism in, managing that relationship. I hope that makes sense.
Absolutely. And I like that you started by, saying it's very important to consider the business objective. I also think it's very important that, as lawyers, when we get engaged to draft a data sharing agreement, for instance, we realize that your obligation there or your duty there is not to be a blocker. Your duty is to enable that processing activity. So just to, sort of add some more context to what we've been discussing so far, for those who are just joining us, we're talking about data sharing agreements, and we've already established that this is a contract that governs what happens when one organization gives another organization access to data, right? It answers a very simple but risky question. Basically, once the data leaves your hands, what exactly is the other party allowed or required to do with it? We've already established that at its core, a data sharing agreement should define the purpose, so why is the data being shared? I think Ikionana did a great job by talking to us about that. She also, emphasized that you need to understand the roles of the parties. So are they data controllers, data processors, or are they joint controllers? We also talked about security obligations, data subject rights, breach response, which is something that Segun also spends time talking about. I think one thing that we didn't mention is the issue of data retention and deletion. Because again, when you're sharing data between two organizations, it's very important to state how long is this data going to be shared for? What can you do with the data that has been shared? And after when the agreement terminates, and of course, this means that there's a termination clause. After termination, what comes next? That's deletion. What data needs to be deleted? How should it be deleted? And all of that. So let's move ahead in the conversation. Let's come back to you, Ikionana, and let's talk about how lawyers address, technical safeguards. So apart from the fact that, a data sharing agreement is, as lawyers, when we hear agreement, there are certain expectations that come to mind. So of course there are parties, some people would even ask, what is the consideration? But data sharing agreements, like we've talked about, are unique kind of documents. So when we look at data sharing agreements, and we've all agreed that there is a technical aspect of it, we're looking at technical safeguards such as encryption, access control, audits, and all of that. How can we as lawyers ensure that these data security obligations are realistic and enforceable? So away from just saying that, yes, there are clauses that talk about, there needs to be encryption. We need to enforce access control, and we must do our audit, maybe data protection audit according to NDPA, right? How can we as lawyers who are engaged in, the drafting or the overseeing of a data sharing agreement, how can we ensure that data security obligations are realistic and enforceable?
Okay, so while I was doing the research on this particular section on this question, I came across something that's a bit distinct from data sharing agreement. It's called a data contract. Now, data contract covers the technical part of everything we are discussing in a data sharing agreement. While a data sharing agreement will look more like the legal instrument for regulatory enforcement and all, a data contract is more for the software engineers. It's more for the back-end handlers. They decide access control. They decide the encryption, everything that you talk about in the law. If it's pseudonymization, for example, they begin to say, how is this data going to be pseudonymized? What data are we collecting? That's what a data contract does. And that's for people who are writing the codes or building the systems. So what you're doing here is we have the laws, the regulations have stated this is what you need to do. You must know that access should be controlled. Now, for the data contract will now say for the software engineers, for the developers, if you key in a particular code or a particular password in the system that is not meant for a user, even if it's me, let's use the common one, for example, when we try to use our email address and we've forgotten our password. You impute a wrong password in your own email, automatically the system sends you an alert in your email saying that someone is trying to log in. Please verify if it's you. And then what is happening here is there is a system with the developers via their data contracts that has enabled them to block access to a particular key code that is not in the system. So while the data sharing agreement is what you're seeing face to face, you're interacting, the organization, the users, or even two parties or whoever data parties that are involved are working. The data contract has already stated them. I don't think that anybody, personally, I didn't even realize that something of that nature could be possible, and that is what usually works for developed countries where they have these systems. People usually build the systems. We are more consumers in this side of the world, so we may not necessarily pay attention to all this. But for advanced countries that develop things like the chatbot, there is a data contract that specifies how each legal requirement needs to be met. And it is built into the system, which takes us to privacy by design and default. And that is one of the ways where you can translate the legal requirement into the technical. So while the legal requirement is pseudonymized, the data contract will say this is how pseudonymization is done. And it is built into the code that runs or into the software or whatever backend that runs the system or runs the software for the user interface. So unless the lawyers understand this aspect, they may not necessarily understand all the technicalities, of course, but they must be able to explain this to the developers. And that is why it's important to imbibe privacy by design and default, because if you have developed a system to an advanced level before you come to the lawyer and you're asking, what do I do? It's going to be this. There's always a hole. There's always a struggle to try to maneuver the systems all over again. But if they are building, if Nigerian system, if users in Nigeria or in Africa can build with these contractual technicalities in mind, what I call data contracts in mind, they will be able to translate from the legal requirement into the technical requirement while building the systems. So that's where I'll draw the curtain for this. I hope I did answer the question.
You did, and thank you so much for talking to us about the data contract. Because it's a common misconception. People usually assume that because we're talking about the data sharing agreement.
Are you there?
Can you hear me? Hello?
I can hear you.
All right. So
Hello?
I was just explaining to Ikionana
Hello?
that it's so good that she spoke about
Did
the
I go?
data
Please, can
contract.
anyone hear me?
Yes, we can hear you.
Damilola, can you hear me?
Yes, wow. I can hear you. I can hear you. Can you hear me?
If anybody is talking, I can't hear my hand. I don't know what's happening.
Peter, I think you can continue.
All right, thank you. So just wanted to buttress the importance of a data contract and what it actually does, you know, and also for us to take notes that whenever you're confronted with a situation where you need to come up with a data sharing agreement, you also need to make sure that you're referencing the data contract. All right, so moving on now, let's move back to Shegun.
Hello.
All right. So Shegun, let's talk about risk, right? Let's talk about the legal risk for organizations in relation to data sharing agreements and how those risks can also link to issues of liability, indemnity, right? So what are the legal risks for organizations when they share data without a properly structured agreement? And how do those risks relate to liability and indemnity for the parties that are involved?
All right. Yeah, absolutely. Thank you for that question. Absolutely. The reason why we are having this conversation about information sharing agreement or data sharing agreement, the initial consideration is actually risk. So as lawyers, the reason why we put in contracts whenever there is a transaction between two parties is to document what has been agreed, and also to put that clarity as to what happens if there is a default in doing this. So contract is a way of mitigating risk fundamentally if we look at it from a broad concept and not looking at it from a data protection perspective. So the risk, like if you default, how am I going to get remedy for that? And what is the process for what's the governing process for more or less actioning whatever that we've agreed upon? So moving it now to data protection context, I think the fundamental risk is with regards to the financial liability and the reputational damage that could come to organization. The whole spirit of data protection or data protection laws is literally putting control into data subjects and giving them a bit of more authority on how their data is being managed. And the law has enabled data subjects to exercise their rights. There are several rights that is contained in the legislation that data subjects can exercise. Beyond that, the law has also created obligations for you as a data controller or as a data processor. Wherever you find yourself, there is an expectation that this is what you need to do. Failure to do this would trigger, penalties, which we all know what the quantum of the penalty looks like from a regulator perspective. So the major risk for just sharing information and not implementing sharing agreements is actually exposing yourself or exposing the organization to that potential financial liability or fine that can come in a case where there is a data breach or anything is done contrary to the provision of the law. Maybe the data subject's right is not well respected. Maybe there are certain principles in the law that has been, gone against. Maybe storage limitation is not well implemented, data is being kept for a longer period. So many issues can come whenever you are handling data. And just to remind us, and for us to also understand that the whole idea of the law supporting how or controlling or governing how data is being managed is not necessarily to take away the possibility of there being a data breach. And I say this often, most of the time, that as lawyers, yes, some of us have technical knowledge, but sometimes you also do not know how to implement those measures to ensure that data is well protected. And that's why our work is not, we are not alone and we don't work all by ourselves. We also interact with other SMEs like the InfoSec and the cybersecurity team in order to implement the technical measures that we might want to recommend for data to be protected. But the whole idea of the law, or basically what the regulator is looking for, is how have you as an organization, what have you done to prevent any major occurrence or a data breach from happening? If you look at the 7 principles of privacy by design, the fundamental one, which is the first principle there, is privacy is meant to be preventative and not it's meant to be proactive and not reactive. It's meant to be preventative and not remedial. So your way of showing to the regulator that you have actually taken steps to prevent any wrong occurrence is by you implementing some of these measures, which, like I said in my previous conversation, that your sharing agreement is actually your first point of call. So let's put it into scenarios. 2 organizations have gone into agreement and you are sharing data, or 2 organizations are going to be sharing data amongst each other. In the absence of an agreement clearly stating whose responsibility it is to respond to data subject request, whose responsibility it is to manage incidents whenever there is an incident around the systems that is managing this data or hosting this data, when there is no clarity as to the purpose, how are we using this data in order to prevent any purpose creep or one party using the data beyond the expected agreement or the purpose that has been agreed upon. When there is no clarity around these issues, then it poses a very huge risk of who is going to be accountable when there is a problem. And if you, as the first point of contact with the data, is going back to the regulator to showcase or to defend yourself that you've done everything required, what the regulator is going to ask you is to evidence what have you done. It's not just by the words of mouth. How have you actually managed? What is your data management practice? And one of the things that you showcase beyond your audit report or evidence of registration is actually the sharing agreement. This is the content. This is what we have agreed between these parties. Another risk there, again, is about the trust within the trust from the customers to the client in question now. So if it's a private entity or is an organization that manage customer data and you are sharing that customer data with other organizations, right? And maybe there's a data breach from the third party organization and the end user, which is the customer, is aware of that data breach. So a practical example, I gave my data to a financial institution, maybe I created an account with them. As part of the arrangement with the bank, maybe the bank has sort of another arrangement with an insurance company or any other financial provider, and there's an onward sharing of my data with that financial provider without clear transparency to me as the data subject. If there is a data breach with that insurance provider, there will be a shock, an instant shock to me as the data subject as to I didn't have any contact with this insurance company. Why is my data sitting with them? And this can be a ground for complaint and claim from a data subject perspective. But if there is no sharing agreement, it will be difficult for you to also execute that transparency requirement from the point of law, which necessitates you to give data subject a level of awareness as to what is happening with the data that sits within your remit as a data controller. So there's quite a lot of risk to mention, organizational risk, which again affects the way your business is being managed. As a proper organizational structure, you don't go into transaction without having things properly documented. So it goes to the root of how the organization is being managed. Let me give the last example before I stop talking. I was speaking to a colleague just of recent, and it happened that there's been an acquisition by the business. So the business has taken over another business, and they've literally taken over the customers of that business. Just thinking about it, think about it like two banks. A bank is taking over another bank. Now this bank has the responsibility to go back to the regulator and showcase how their data is being managed. Now, at the initial stage of the acquisition, there was no sharing agreement, there was no data transfer agreement, there was no clarity as to this is the purpose, this is our lawful basis of companies A, lawful basis of holding that data in the first place. Now that the business is being transferred to company B, that data agreement, data sharing or data transfer agreement would have given clarity as to what is the expectation of company B so that they can continue compliance with those things that initially has been written. But absence of that agreement is actually throwing the company into a serious issue at the moment because they do not know how to demonstrate compliance because they just find themselves dealing with customers' data. They retained the name of the former business, retained everything, but it is a change of corporate structure. And it's from a corporate governance perspective, there ought to be a proper arrangement before taking over the entire business. I'm just going to stop on those few risks that I've mentioned. There's a couple of more that we can mention, but because of time, I hope that that also answers it. Thank you.
Thank you so much, Shegun. That was very detailed. Thank you. I think you'll agree with me that my speakers for today have done justice to this topic, especially in terms of giving us a business strategy perspective, commercial perspective, and a practical implementation perspective. So thank you so much to our speakers. So to round up, what is one practical advice that you would give to young lawyers who want to specialize in data protection, privacy, data governance? Seeing as you've spoken extensively on this subject, I'm sure that there are people on this call who maybe that's not their area of practice, or maybe they've come across it once or twice and they've just been wondering, you know, what's the big deal? What's the hype? You know, is this something that I can also do? What advice would you give to them?
Sorry, who's going first?
Since you're unmuted, you can go first.
All right. Yeah, interesting. Okay. There's quite a lot of advice to give, but I think the first thing I would say, from at least the way I've also grown into the industry, is to number one, understanding that everything is changing. I think we are in a dispensation whereby it's okay not to get everything right, if that makes sense. So there is no pressure on you as a young lawyer that you're trying to get into this space and things are not looking clear. That's why we have community of lawyers. That's why you have senior lawyers or people who are more experienced that you can pick their brain and understand how things are being done. And I said this because the world of data, the world of technology is not the same. Things are changing every day. I was saying to a group of people yesterday that the life of a data protection officer or a privacy lawyer is not the same. You don't meet the same scenario every day. You have to apply all of these principles to meet different needs, different business objectives, complex situations, complex scenarios. And at the same time, if you are not doing, it's a very tricky position because you are there to be a business enabler. And at the same time, you are more or less the eyes of the regulator within the business. So if you're not supporting the business to make money and make profits, you might not be paid because that's basically what the client needs. They want to do what they need to do so that they can make money. Your clients can come to you and say they want to sell personal data. How would you advise? Are you just going to go, hell no, you cannot sell personal data? Or are you going to try and understand what are the chances? What is the lawful basis? Are you going to still support that business in applying the right principle, or you're just going to initially at the beginning of the conversation just go against it? So I say this to mean that it's okay to feel confused. It's okay to feel like you don't understand fully, or you wake up every day and scenarios are changing. There is just different way to view things. It's okay to feel that way, and you just have to know that the way forward is to leverage your community, leverage on the knowledge of other people. The knowledge of data protection is quite very interesting because the way it is being applied in a certain industry, even though it's the same principle, you can go to another industry and it's a different ball game. I work in the healthcare sector, and the way I've seen and appreciated data management is quite different from someone who probably sits within the remit of those who are supporting maybe crime prevention industries, or you are working for a client that is into fintech, finance, or agriculture or education. These are different industries with different nuances and different flavor to them. So it's okay to not feel like, oh, you don't know everything. You just need to try as much as possible to exercise patience and learn. Learning is everything about this industry. And the best way to learn is to interact, hear other people's opinion. I've learned on this call, I've learned new things from from the other speaker. And I'm sure that learning cannot end. We just have to keep learning. So I hope that wraps up my my opinion and my advice for anyone that is
Thank
thinking of
you.
this sector. Thank you.
Thank you so much, Shegun. Thank you. Ikionana, let's hear from you, please.
So I think Chego has done a lot in terms of the beginning. So I'm going to take over from where you left off with saying that when you come to learn, don't come empty-handed. Please do not come empty-handed. Most persons feel that as a mentee approaching a mentor, they they don't have anything that the mentor may need or some kind of knowledge. Now, let me share a practical example. I have people who are interning in my law firm, and I always say when I drop a particular task, or I am the one that came up with the document, and I drop it on the group and I say, vet, most persons will say, oh, it's okay. You're the expert. You know it. No, please don't do that. Criticize. Come with your brain. Don't leave it at home. Don't leave it thinking you have gotten nothing. As you're learning, be of use to the person you're learning from. I mean, I'm giving you my experience. I'm giving you my brain. These are things that I took time. Your mentor took time to learn. What about you? What are you giving to the person? Are you easing the person's pain, or are you adding up? It takes a lot to share what you already know. Unless someone who's very passionate about everything, even with that, the weight can be a lot. So when you come into the room with something you have to give as well. Don't just come with the take mentality. And then also, certification is very, very important for people who are into the field. If you look at the assessment criteria that are in the guide, you'll see that you have to get certain certifications. Even let me use a simple compliance like registration with the NDPC. You need to have a certification to be able to conduct that. So start planning early. And these certifications are not cheap. Nobody should deceive you. They're not cheap. They're quite pricey, unless you are. I mean, you planned for it, but as a young lawyer who is just starting out, or you have a supporter, you have a sponsor. Otherwise, they are pricey. So plan for your certifications early and acquire them. It will give you leverage over certain situations. And also continue to learn. Go beyond Nigeria. Go beyond Africa. Look at what other laws say. What because one of the most important things as a privacy professional is the relevant provisions of the law. Whatever law that you're looking at, whatever jurisdiction you're looking at, the first point of call in an instance. So if you're dealing with EU subjects, data subjects, you know what law applies. So all of that is very, very important. is what I will say a lawyer needs, who is coming into data protection and privacy, and also adaptability and flexibility. What tools do you know how to use as a lawyer and data protection and privacy? You may need to understand technical skills as well. So maybe the technical aspects of it, you're hearing of pseudonymization. How is it done? How does the code read? If I give you a plain code, you know, one of the questions Chira asked me was, how do we merge technical part with the legal part? If you are someone that can look at a code sheet and the command is something you can understand, I mean, you are very good to go. You can be able to work with the technical team to set up compliance in the organization. So, to sum it up, I'm said that the first thing is come with your head, come with your mind, come with your spirit. If someone is teaching you, be ready to give back to the person. Don't come with the old I receive, I receive. No, please don't do that. Leave home and come with your mind as well. The mind of your own, your opinion. Secondly, get certified. All right. It's important for you to be able to have leverage, get certified, get certifications, attend trainings that could give you recognized certifications. And then finally, I said, be able to adapt, learn the technical aspects of it, understand just beyond pseudonymization. How does pseudonymization work? Encryption, what does encryption mean? Access control, how do I control the access from the back end, front end, or even for a physical office? How is access control done? Do they use fingerprint? Do they use password? Understand it, and it will help you grow as a privacy professional.
All right, thank you so much, Ikionana. That was very detailed. And thank you also to Shegun. Thank you to everyone who has.
So that's where I draw the curtain. So over to you. Thank
All right,
you.
thank you. Thank you so much. I see that Abdul Hakim Isao has his hand up. If you have questions, you may put them in the chat box, please.
I think we have a question. Someone asking the recommended certifications. Though I posted, but maybe if you can speak to it.
I see that there's already a response to that question, so perhaps we should move on. All right, in the absence of any other questions, I'd like to thank everyone who made out time to join this conference. To all our esteemed speakers, thank you for accepting the call to join the webinar and to share your knowledge, your experience, and your expertise with us. It's always a delight, to gather here and learn something new. To the members of the committee and the subcommittee, I'd also like to say thank you for giving us this platform as well. All right, so yes, Obina, I can see your hand is up.
So I don't think it's a question. I don't think it's a question.
Okay, all right, that's fine. So I think we can now bring this meeting to an end. Thank you everyone for being here. See you next time and have a blessed day ahead.
Thank you all for joining us. We look forward to seeing you next week when we'll be bringing another webinar from another subcommittee in the TMT committee. Please make the date with us. And once again, don't forget to register for the MBA SLP conference. The early bird registration is still ongoing. Please take advantage of that. And we look forward to seeing you in Lagos. To catch replays of this, to catch a replay of this webinar and all previous webinars in our committee series, please check the MBA SLP YouTube channel. You can always rewatch them there. Once again, see you next Thursday, same time. Enjoy the rest of your day. Thank you. My name is Damilola Victoria Labi, Secretary, MBA Slp Tmt. And on behalf of the chair of the committee and the section chair, we say thank you for joining us. Bye-bye.